preliminary objections, counter affidavit, or any other process will be held on the 5th of May, which is like a composite, so that His Lordship can deliver a composite judgment.
In a significant development with far-reaching political implications, the court has delivered a ruling that clears the way for a full hearing of a crucial case involving several political parties. The plaintiffs had earlier filed a motion seeking to amend their originating summons, a move strongly contested by the defendants through counter affidavit and preliminary objections. After hearing arguments from both sides on April 17th, the court adjourned for ruling, a ruling that has now tipped the scales in favor of the plaintiffs. Delivering judgment, the court upheld the amended originating summons and ruled that all processes filed by both the plaintiffs and defendants were properly submitted and served. More importantly, all political parties mentioned in the suit have now been formally joined as defendants, making them proper parties before the court. This decision effectively sets the stage for a comprehensive determination of the issues at hand. The court further directed that all parties must file their processes on or before May 5th, the same day fixed for the hearing of the substantive suit. A composite judgment is expected to be delivered thereafter, a move seen as an effort to ensure swift resolution, especially in light of the electoral timetable released by the Independent National Electoral Commission, INEC. The presiding judge emphasized the need to hear the matter on its merit, ensuring that all parties understand their legal standing before the commencement of primary elections.
Preliminary objections, counter affidavit, or any other process will be held on the 5th of May, which is like a composite, so that His Lordship can deliver a composite judgment on that day. And we are happy that His Lordship is, address his mind to the fact that this is a very sensitive matter, it's a political matter, time is running, and like His Lordship said, he wants the matter to be heard on merit so that parties will know their fate before the primary election fixed by INEC.
Also reacting to the ruling, Chairman of the Board of Trustees of the National Forum of Former Legislators, Honorable Raphael Igbokwe, described the judgment as well considered and timely.
We see this as a well-considered ruling on our application for amendment of the originating summons to join necessary parties. And in the wisdom of the court, the parties so mentioned are seen to be necessary parties who ordinarily need to be heard if the suit had come up. So the court has granted leave for the parties to be formally joined. And so all parties now are formally before the court. So the stage is clear for the hearing of the substantive suit.
He further noted that the court recognized the urgency of the case, especially given the tight electoral timeline, and has therefore ordered an accelerated hearing. According to him, the suit seeks a judicial interpretation of Section 225A, particularly regarding the eligibility of certain political parties to continue to operate within Nigeria's democratic framework. He stressed that the case is not targeted at any specific political party, but is aimed at strengthening Nigeria's electoral jurisprudence and reinforcing the rule of law.
The crux of the matter is that we are seeking for interpretation of Section 225A as to the eligibility of some political parties to continue to exist as a political party. And we don't know why there's so much delay in their responses. If somebody had approached you and said, no, you can't be in the university, you don't have 5 credits. If you have the 5 credits, you present it. It's as simple as that. And we are concerned, especially the Accord Party. They don't want to be part of this suit. They are doing everything to delay this suit to make sure that the matter is not heard. But thank God today, the stage has been cleared so that our activities of every institution, persons, and authorities in this country can be carried out according to the law. That is the expectation of any nation operating constitutional democracy or rule of law. And this is where we stand.
With all parties now before the court and timelines clearly defined, attention shifts to May 5th, when proceedings on the substantive matter will commence, a date that could prove pivotal for Nigeria's political landscape.